Friends, I welcome all of you to the second technical session. We have with us on the dais Mr. Nilimesh Barua, Director Serious Fraud Investigation Office, Mr. Manmohan Juneja, Registrar of Companies, Mr. Nisar Ahmed, Immediate Past President ICSI, Mr. Deepak Kukreja, Madam Ashu Gupta. I request all of you to kindly give them a big round of applause. I request Mr. S. Kumar to kindly come and present a flower bouquet to Mr. Nisar Ahmed. Nisar Ahmed is past President ICSI, needs no introduction. So big round of applause for him. We also have with us Mr. Nilimesh Barua. He is presently Director Serious Fraud Investigation Office. SFIO, as you all know, that multidisciplinary organization to investigate the serious financial fraud. The organization is having experts from financial sector, capital market, accountancy, forensic audit, taxation, law, information technology, and so on and so forth. He is IRS officer 1985 batch and on deputation as JS cum director. MA Economics, Delhi School of Economics, LLB Punjab University, MA Finance, City University of New York. So I request Mr. Sachin Agarwal to kindly come forward and present a flower bouquet to Mr. Barua. So friends, in the first technical section we have already discussed governance, scrutiny, investigation and investigation. This session we are going to discuss serious fraud investigation, its office, its related function, offenses and compounding thereof. So I have already, Mr. Juneja's profile has already been introduced. I once again welcome him and request Madam Ashu Gupta to kindly present flower bouquet once again. Sir. Once again, welcome, sir. So straight away, we are going to start the session, and I am handing over mic to Mr. Nisar Ahmed, session chairman, to start the proceeding. Mr. Nisar Ahmed, please.
Good afternoon, ladies and gentlemen, our esteemed colleagues in the dais, Shri Barua and Shri Manmohan Juneja ji, my colleagues in the chairman of the region, Mr. Deepak Kukreja, Ranjit Pandey and Ashu, other senior members of the profession, past chairman of the region, other office bearers, ladies and gentlemen. The topic is today I enter into the hall, let me very confess with you, I was not aware of what is the broad topic of discussions of today's seminar. It's my fault. Deepak has sent it one email that has gone different loop. It was not there in me. I checked up with this, whether it is confirmed, what is the program. He sent me 3 days back. I see the contents. He called me and then put it, these are the topics to be discussed in the second technical session. But I was not aware of the broad, theme of the discussions today. When I saw it here today, it gives different dimension to me. And I started out thinking, what is the theme is today for discussion? One is governance, another is fraud and, detection of fraud and investigations. And two are different, extreme. When there is a governance, there is no fraud elements. When there is a fraud, there is no governance. It is a mismanagement, and governance is not there. So it is how we are going to bridge the gap. I am told the first session, technical session, we had spent 3 hours on debating the governance, the various elements of governance, and what are the all modes, and how you are going to deal with all those aspects, and to minimize the fraud, to minimize the outreach of regulators into your premises. And, that was the broad conference. But then I had the opportunity to listen to our friend, Registrar of Companies, Delhi and Haryana, Shri Juneja ji, and he has talked about fraud, and he defined 447, 448. At the moment he was talking about this, how this, going to develop. So I also participated in the questions answer session, lot of apprehension from the fraternity of the company secretary that why they are being now subjected to all kind of things. Let me very honestly share with you, friends, it is not the company secretary alone. Why company secretary or any other professional should be afraid of if they are going to strengthen the board process. That is a major pillar of the governance. And the board process is the one of the major pillar of, you can say, the governance. There are 4 pillars of governance, but this is the one of the pillar where you are directly associated with. And if you look at these parameters of the board governance and board processes, I don't think we are now expecting the regulators to visit to your premise. Try to be a good citizen, good compliance person, and that is the note with which we have been now debating, and I'm thankful to NIRC for having a 2 different dimension to be discussed on the same day, the governance and the investigation portion. So as you know that the board process where you have been fully engaged yourself and from the very beginning when you joined this profession as a students and thereafter continuous, we always talk about how to manage the board process, and board processes has around various elements of how to educate, training, development, succession planning, and so on and so forth, risk management, mitigations, all sorts of areas require a kind of inputs from the professional like company secretaries. Other professionals are all there, but he is the one who is very closely working with the board. And if the board is now upright and having fully knowledge of and completely engrossed upon the compliance metrics, I don't think you have any afraid of having some kind of mindset that I am afraid of somebody is going to knock my door. My colleague has also mentioned about how long, if I left the organization, how long I am going to be chased by the regulators. And someone has gone to say that yes, you are participated in the formation of company. Till the company alive, you continue to be there. So these are the 2 extremes today we are going to debate. Fortunately, we'll discuss. I'll leave my comments for the end of the day after discussion. But definitely, we have chapter 14, which typically is very, very important. Wherever I go and participate in the debate, I always talk to my friends that 25 section or 24 section put together called chapter 14, you must be fully take it into your life. Understood fully how you are going to guard these sections or these provisions from your organization. It is not a bad idea to invite the regulator to have a coffee together in the evening or maybe sometime. But it's not good to have regulators sitting morning till evening, looking at your papers and vouchers because you are not a governed company. You are not providing the information. So sitting at the evening with the IIC or some hotel, have some coffee and tea, it's a good thing to have a relationship with the regulators, but not as a good thing as a professional to invite a regulator at your home in the morning 9:30 or 5:30. SFIO, in regard to section 2126, friends, section 212, particularly SFIO, he is empowered. Now today, what SFIO today we understood, and so far we have seen the SFIO. The SFIO under the new Act 2013 is going to be a much more a different SFIO. My friend is going to take this very detailed aspects. I don't want to preempt what he is going to talk, but definitely, if you are inviting 212 subsection 6, only one subsection 6, where 15 actions, I have been telling wherever I go in the seminars, and I always ask my friends, particularly company secretary or chartered accountant, I also address chartered accountant fraternity here and there. I always talk about, please read chapter 14 very carefully. Only, don't read 29 chapter, but you read if you want to survive as a good professional. And I also appeal here also, before my two colleagues to go and make a presentation on their respective allocation of the work that has been now assigned, adjudication of offences, etc., etc. I'll definitely appeal to all of you once again for the sake of repetition that you must go to 206 to 229. Kindly read this section, chapter 14, and if you understood chapter 14 carefully and guard your organization, and then you have a friendly relationship with the regulator called SFIO or registrar or the inspector under the act for coming to, all right, then they are coming once in 5 years. Anyway, we are expecting the more and more regulations to be looked into, and that is the law. And today we have now in e-governance model. And in the e-governance model, you know, by a click of button, you know what kind of compliance and non-compliance are there. And today we are going to have a special court. And a special court is going to don't expect the 10 to 15 years time to adjudicate your matter in the magistrate court, which is being filed in Tisajari. In case of Delhi jurisdiction, you go to the Tisajari. And then many times you see, you have a report, OVVAS committee report, says 15,000 summons were not served even. And because of that reason, that is the report. Conduit. That because of that reason, the matter could not be reached to the, finality. No more prosecution. No penalty is imposed. Now today we are going to have a new regime called a special court. Here is the adjudication of offences. We are going to have one particular section 454 is going to deal with adjudication of penalty. You go and have the golden sack hand if you have some violations. At the same time, you are also looking 441 for, you can compounding. They have another way up to go for compounding. Today my friend is going to take this matter perhaps. I think you are going to take this. But at the same time, afraid of 212. 212 is one section out of 24 sections which I am referring to. You always think and go with him and discuss as a kind of advanced ruling kind of discussion. If you have some discussion in your mind. With this opening remarks, let me, close my part of opening part. And I request my friend, Mr. Barua, to first make a presentation on his part of SFIO and the topic that has been given today for compounding. What is the topic? Functions and role and powers of SFIO. My Barua, please.
Thank you. Thank you, Mr. Nasir Ahmed. My distinguished dignitaries on the dais, office bearers of the institute, and friends. It's a very, I believe you all had a very good lunch. I had a taste of the lunch, the excellent lunch. But it creates problem for the speakers in the post-lunch session. I was told that, this is a doctor's advice that after lunch you should take a nap because your entire blood rushes to the stomach to help the digestion of food. But what happens, somewhere when the blood is rushing to the stomach, you feel light. So if anybody feels sleepy, don't feel guilty. That is, I'll take it on me that I have not been able to make a thing interesting. So with that, I'll start. You see, in our SFIO, we've been discussing about a concept called 360-degree profiling of a company. Now, I realize that how difficult the 360-degree profiling is going to be. Here, the profiling is 180-degree. I'm finding it difficult to look at from that corner to this corner. If one has to do a 360-degree profiling, it's going to be extremely difficult. So I think in that case, all of you will have to work together to get a complete perspective of the corporate world. And I'm sure you are going to help us to implement this new Companies Act 2013. With this, I just want to make I'm not going to talk about specifics of the Companies Act provisions, because I'm sure you all you have read chapter 14, chapter 14, yeah, chapter 14, you all must have read, but I like to give a perspective rather than going specifically. It's not a discussion for teaching the provisions of Companies Act. Just my perspective I would like to share. So please keep that in mind. It's not going to be an exhaustive section-to-section analysis of the provisions under chapter 14. I'll just discuss overall perspective, and of course we'll discuss the sections also. So let me, This is the structure. I'll make certain opening remarks. SFIO then, prior to 2013, SFIO now in the new regime. And then, of course, what are the challenges we are going to face, challenges ahead, and some concluding remarks. It's going to be a short presentation. We can discuss later on. I'll just give you an overall framework. We are neighbors now. Why neighbors? Chapter 13 talks about special responsibility for the company secretaries. And we are in chapter 14. SFIO has been created, very close section. I think 206 talks about company secretary. Yes. And we start from
203, 204, 205.
5. We start from 206. So we are neighbors. Let's be good neighbors going forward. So I have carefully read the sections relating to the new, of course, it's very important that there'll be secretarial report, which is going to form part of the audit report now. There'll be secretarial standards, which you already have. I believe there'll be some kind of an adjustment to be made to be aligned to the new Companies Act. That's what I was told by one of the members. And Board of Directors is to make observations, explain if any qualification is made in the report which is prepared. And of course, there is a provision for, in case of default, there's a liability of punishment also. So we start as the good neighbors. All of us collectively is the government, SFIO, and the company secretary fraternity is going to have a responsibility, which is, I would call it collective responsibility. It's under the Act. We are accountable for doing a good job. You are accountable to help the company to make compliances easy. So just on a lighter vein, I'd like to share something with you. The way I look at the collective risk all of us face, government, SFIO, and the fraternity of company secretary. It's a lighter vein, but I'd like to share with you. Anyone has read Divine Comedy? I mean, I read in school Divine Comedy, more about the love story of Dante and Beatrice. But latest it's become very popular because of the book by Dan Brown, Inferno. So it's a very interesting story. I don't know if you're aware of the history of what happened to Dante. In Florence, I think in 1430 or around that time, in Florence was a city-state. Dante, there's a political conflict was there. Church took over. Pope took over. There's a group called Black. I think Black and some other distinct. The Black was led by Pope. And the whole process, Dante was a very famous poem that time. He was exiled. The Black took over the rule of Florence. The Dante was exiled. And then he goes to hell. What happens in hell? This Inferno, where Divine Comedy, the part of the Inferno talks about his experience in hell. I just like to share with you a little bit about that. 3 minutes, then I'll come back to the main topic. So, collective risk I'm talking about, we all might land up, apart from my accountability on earth, when we are alive, there could be issue about getting some problem with if we land up in the 8th circle of hell. Dante talks about the 8th circle of hell. 8th circle is a very interesting circle, I'll show you. And then there's a character called Geryon. He's supposed to be the monster of fraud in hell. The third character is Virgil. Virgil was another very famous poet in Italy around that time. When Dante was alive, he was dead. You know about Dante's love story, that Beatrice, whom he had loved, she died pretty young. So, Dante was exiled, he goes to hell. This is the description, this is actually the pictorial, it's a very famous painting by Botticelli. This is the map of hell. This has 9 different circles. And the most important circles most difficult circles are circle 8 and circle 9. That is supposed to be reserved for people who commit fraud and serious fraud. So we might land up there in case we may not be accountable here, but if we help fraud or if we cannot stop fraud, we may be liable to land up in hell, maybe on the 8th or the 9th circle. It's more to it. Geryon is a monster. When Dante landed up in hell, so Virgin Mary thought that poor guy has come, he's all alone. So let me send someone. He sent this person, that another poet, Virgil was saying that, okay, you give him a guided tour of hell. So that is how he starts. But it's so difficult after the 7th circle, when the serious people who have committed serious fraud and fraud, who are in 8th and 9th circle, they are housed for punishment. So he said, you cannot go on your own. You need to have this person, monster of fraud, Geryon. I mean, it's very interesting. Look at this. He is a human being, looks like an angelic kind of a, very serene kind of a face, but he has that pause, and he is like the dragon. So to reach there, people who are punished for committing fraud and serious fraud are in 8th and 9th circle. Even in hell, you cannot go there very easily. You have to take help of, you need a guided tour, and you need help of a monster of fraud who's Geryon. So Dante sits on his back along with Virgil and goes there. And the description, what he sees there. See, the 8th circle, there are 10 pouches. And the 8th pouch, it's like 10 different compartments. On the 8th compartment, that is meant for people who have been counselor to people who committed fraud. So that's a very specific place for all of us. If we do wrong counseling to a company for committing fraud, we'll land up in the 8th pouch of the 8th circle, and this is what the punishments are. They have described in detail what punishments are committed. I've just taken 4 pictures. It's a terrible kind of punishments. So that is where it's in a lighter vein, we have a collective risk, and I think all of us, the way we manage our risks together, we take steps. We must take steps to do our job well. On my part, to detect fraud and prevent fraud. On your part, not fraud happen in the companies you are managing. Okay, with this little background, so I'd like to come down to the main topic now. That just briefly about SFIO then. Before 2013, SFIO was started in 2003 by way of an executive order. So SFIO is supposed to be working in a multidisciplinary team. We have people from different organizations. Like we have people from Indian Revenue Service, we have people from Customs Service, we have people from Indian Police Service, we have bankers, we have company law experts, we have legal experts, we have forensic auditors, information technology people. So we have a various people from different background. So we'd like to look at a particular case from all perspectives. That's why I call it 360-degree profiling of a company would like to do. Now, of course, 2 sections under the Old Companies Act, 235 and 237. 235 is referred by the ministry on certain, there are certain conditions to be satisfied. Otherwise, 237 is by different judicial authorities who are giving case to SFIO. And in between, 2008, we started a sub-unit within SFIO, that is Market Research and Analysis Unit. So SFIO then was on the basis of an executive order, multidisciplinary organization, doing investigation under 2 sections, 235 and 237. And we have a market research unit, which is trying to analyze the market and see what is happening. So that's what SFIO earlier. Now, this was the original charter. I don't have to go to the details, but this basically, the cases were referred to SFIO, looking into the complexity, whether it's a complex case, and it has interdepartmental manifestations, and it's multidisciplinary. So on that basis, as per the old charter, cases were referred by the ministry to SFIO. Now, substantial involvement of public interest. That was the guiding factor for referring cases to SFIO. If in terms of no specific monetary limit was given, in case it's a substantial public interest is involved in terms of people involved or monetary misappropriation. So that is what the charter was. And it was expected that SFIO, after doing investigation, will come up with certain guidelines to say that how can you make, do we need to change laws, do we need to change procedures, or any system improvement. And company laws, I can share with you, over the last 10 years, what SFIO gained, the difficulties it faced, all that thing, New Companies Act, the provisions which are there now, it was part of the recommendations by SFIO on the basis of his experience, the difficulties faced in the last 10 years. So we take some credit for enacting the provisions relating to SFIO under the New Companies Act 2013. So now SFIO is going to be a statutory body. So that's under Section 211. It's going to become a statutory body. It'll have a new notification has to be done. Then powers conferred under Chapter 14. And the very important part that fraud has been defined for the first time under the New Companies Act. It was never defined earlier. So we had a lot of difficulty. One of the operational difficulty of SFIO which we had under the earlier act, that we are facing currently we are facing a challenge before the Supreme Court, whether SFIO has jurisdiction to file cases under the IPC or not. That was one issue. Now, we have been filing cases both under the Companies Act as well as under the IPC also. The reason being, because fraud was nowhere defined under the Companies Act. Now, when we feel that, say for example, IPC talks about cheating, it talks about criminal negligence, it talks about, there are various aspects lost to the company. All these things were not specifically defined under the Companies Act. So when we feel that two enactments are so closely related, if you're talking about 628 under the Companies Act, there's a falsification of accounts, it is a very similar provision in 477A of the IPC. There's a slight technical difference, but these are very, very closely linked. In those cases, we cannot assume jurisdiction straight from the police, straight from IPC. We cannot say that we do not look at Companies Act, we are straight away going to 477A. That jurisdiction doesn't have, the Constitution does not allow SFIO to, that is a state, IPC is to be administered by the police, state police. So this was a very, very serious problem with us. For all the 10 years we've been filing, we are fighting the case in the Supreme Court now. We are saying that if it is inextricably related, IPC offense and the company law offense are related, we can file a complaint against both the acts, but jurisdiction has to be assumed first by, under the violation of the Companies Act. So you'll see that that is a very significant thing under the New Companies Act. If you know this background, you know that how fraud has been defined in 447 in an explanation. And the way fraud, that the cognizable offenses which have been given in 212(6), you will see that we don't have to travel beyond the Companies Act anymore. So irrespective of what happens to the decision in the Supreme Court, now 2013 law has taken care of this particular aspect, that fraud is comprehensively defined, and we can do everything possible, all investigations, all punishment under the Companies Act. This is one significant development so far as the 2013 Act is concerned. So, broadly speaking, these are the 5 important features. We'll come down to little more detail. Statutory organization is created in the name as SFIO. Fraud defined. Punishment for fraud is also defined, and it's a substantial improvement. I mean, I don't know whether I should call the word improvement, but punishment is quite substantial now for committing fraud. Then other one is about various powers to conduct investigations, then provision for special court, and enhanced punishment fraud under Section 447. These are the broad features under the Companies Act 2013. Now, I'll come back to the earlier one. I have a detailed presentation on the provisions relating to SFIO under the Companies Act, but I don't think we'll go through one by one. I'll just quickly take you through just to say that what is the essence of these provisions. Can you see this? Okay, just quickly that 206 is Mr. Juneja's jurisdiction. I think first before up to 210 is jurisdiction of ROC, exclusive jurisdiction. We can enter, but it's basically his jurisdiction. So he would explain that he has very the powers given to ROC is very, very concrete. At times it's present in SFIO also. So we'll not go into detail, but under the old Act, one important factor was that every case referred by the ministry had to be first studied by ROC. Only on the basis of ROC's report under section 234(6), the case could be recommended for investigation by SFIO. That is one significant, that has been changed under the new Companies Act. I'll come to that. So, Mr. Juneja and ROCs have this on 209, very significant part of search and seizure. It is search and seizure, isn't it? 209 only, no?
Inspections.
Okay, now it is much more comprehensive, but I think you have to, ROC has to go to the special code before conducting search and seizure operations. Whereas that under section 220, powers given to SFIO does not have to go to before a special court. On its own, it can conduct search and seizure operations. There's some, you can read in the minute details afterwards, but there's a distinction between 209 and 220. Both are relating to search and seizure operations, one by ROC, one by SFIO. Now, so this is about 210. This is about investigation into the affairs of the company, but this is more in the domain of ROC. I'll come to what SFIO. 211 creates SFIO. Now, under this, there are 2-3 important aspects that looking at the complex nature of fraud committed by companies. So, it has been expanded. The skill set required within the government is much more than the traditional field of, say, company law. There's a provision, other fields to be prescribed in the rules. So under the rules, we are prescribing certain other areas. Now, for example, data analytics is one area I would like to share. Not to caution you, just to say that to share. We are creating, SFIO has created a forensic lab. This is the last, it's become functional now. The forensic lab, we get the digital data from various, it can be different databases, and we have a facility now to do the entire forensic analysis there, and we can come out with what is the different patterns in the database. So this is one facility which has been created recently. So under the Companies Act 211, we are supposed to specify other specialized areas where we need to have our own expertise. That is, under the rule, we are specifying things which includes cyber forensic also. That's one point. This is about 212.1. It's very interesting to read. I'll just make small observations about 212.1. If you look at it, it talks about when a case can be referred to SFIO for investigation. Number one, it's the traditional one that on receipt of a report from the registrar of company. That's the old one. Now, few more things have been included where your role becomes important here. Passing of a special resolution by the company. If company passes a resolution and said that that company's case needs to be investigated by the government, so the government can give it to SFIO. It means for the first time we are talking about, Junaid sir, please correct me, I think first time we are talking about that company management also has to play a very proactive role in stopping fraud. It means company can pass a special resolution, and by virtue of that, company secretary, who's supposed to be the in charge of compliance to laws, company laws and other laws, they will play a very important role in keeping their eyes and ears open. That if something is going wrong in the company, it can put up to the management that to pass a special resolution, get it investigated. I think some cases we have investigated in the recent past, you may be aware. It started with company filing a complaint, lodging a FIR. So we had to investigate the entire case and came to certain conclusions. But now there's an enabling provision by way of a special resolution by the company itself. That's a very significant change from the earlier act. Other one is public interest. In public interest, the government can suo motu order investigation. Of course, the public interest needs to be defined. It needs to be debated. I think then all of us probably put together, we can apply our mind and say that this is what public interest. Earlier charter had some notion of public interest, so we will crystallize at the time of notification. This will be put on record. And another important part is request from any department of central government, state government. This was, I think this is also a new provision. This is also a very significant departure from the earlier one. Now it means, along with this particular provision, a new regime is going to be created, which we'd call it inter-organizational. That has been a major issue. I'll just take an example and explain it to you what I'm talking about, the difficulties we had in terms of inter-agency coordination. Now law has provided for, if Income Tax Department refers a case to SFIO or the central government tomorrow, said here is a case, we feel that it needs to be investigated. It means two departments are joining hands together to look at fraud and come to the logical conclusions. Under the special act, could be income tax, could be customs act, could be a state act like money circulation, that price cheat and that kind of act. It could be any kind of act which is being administered by the state government. So here is a section which brings interagency coordination. It's given a very formal recognition of that aspect here. So that other details may not be of relevance. So now, as I mentioned, that interagency coordination is an important part. Here, it makes it more formal. So if a case is assigned to SFIO by the central government, no other agency will look into that particular aspect under the Companies Act. So there will be interagency coordination. They are supposed to hand over all the documents if they have already started investigation, or if SFIO does investigation and will be legally bound to pass on information to those agencies which are relevant for them. It means the government is trying to look at fraud from all perspectives. It's like the 360-degree profiling of a company. All special acts, Companies Act, all act put together, there could be action against a company if fraud is committed because of, by virtue of this provision, where interagency coordination is inbuilt into the substantive law. 212(6) is a very important, significant section. It talks about cognizable offense. Now, 447 section talks about punishment for fraud. Punishment starts from 6 months to 10 years. And if public interest is involved, the minimum is 2 years. So from 4, we need to read these sections, chapter 14, with 447. And 212(6) is important to be read together. 212(6) talks about, it gives you certain offenses under the Companies Act, specific offenses under the Companies Act, which are cognizable. Cognizable meaning you can arrest the person responsible without a warrant. That is the cognizable. So, in the earlier Companies Act, you please correct me if, so earlier Companies Act, only one provision was there, 58 AAA. Under 58 AAA, anything to do with public deposit was the only cognizable offense, rest were non-cognizable. Now, there's an expanded list of offenses. Very interesting. I'll not read those details about the section, but it can give you an overview. In the next, if you read section 212(6), it has mentioned number of subsections, sections under the Companies Act. One is 75, 76, 34, 36, 38.1, 47, 46.5. These are, if you look at, do a mapping, I think that is going to help you ensure the compliance is being done properly. These sections put together, if you read 447 and 212.6 together, you'll see from entire life cycle of a company, from the point of registration of the company till the winding up. All these sections are given in section 212.6 by making it a cognizable offense if there is a violation of any of these provisions. And these provisions are covering entire life cycle of a company from its, right from the inception till winding up. That's a very important, I feel a very important way, the way law has been framed. I'll repeat this because I think it's a very important point. As a responsible person for compliance for a company, your role would be to look at the company from inception till its winding up. There could be violations all along the life cycle of the company. If that happens, that becomes a cognizable offense, which is punishable under section 447, which has punishment from 6 months to 10 years. If it's public interest, its minimum is 2 years. So this is the crux which is very important. Along with this is also about the arrest part of it. Now, if it's a cognizable offense, the persons responsible can be arrested without any warrant. Of course, all of the safeguards under the Constitution, everything is going to be, it's all available. But the point is for these offenses, so these are the offenses one has to be very careful about. And it can happen anytime during the life cycle of a company. So, I'm leaving this presentation here. You can just try and do a mapping of 447, 212.6 and the sections provided there and description of what it means and the entire life cycle of the company and what would be your responsibility as a person responsible for compliance of the Companies Act. So I think it could be a very, very helpful kind of understanding of the Companies Act under Chapter 14. So these are different sections which have been provided, and these sections are, now if you feel the company is committing fraud, right? The whole purpose is to commit fraud. Like we've come across a number of investment fraud in the country today. The whole purpose is to collect deposits from public and not to return any money. So the life cycle of such companies, they can call it a chit fund company, they can call it a simple, any kind of an instrument they are devising it. If you are part of that company, that if company is fraudulently coming up with some structured kind of a product, they can call it optionally fully convertible debenture. You can call it a NCD, non-convertible debenture. You can call it a advance against product. So any of these, if you are part of that company, you have to be vigilant enough to say that, because this is a definition which makes it a cognizable offense and which is to be punished under the definition of fraud under 447. So these sections need to be very carefully studied and understood. So these are, again, I'm continuing the same section. These are different, I think 15 sections which violations of which are cognizable offense here. Yeah, 448, I mean all these are, so in that case, it's referring to the arrest part of it. Since it's a cognizable offense, that arrest, the bail, before we giving bail, public prosecutor has to be given a chance. So all the details are given there. So the essence is that from the entire life, covering the entire life cycle of a company, there could be violations which could be serious in nature, which is covered under punishment under section 447, and violation of any of these would be a cognizable offense. The responsible persons can be arrested without any warrant. So this is about information sharing that we have already discussed. Yeah, this is about the procedure. 212.8 talks about it's more about the arrest part of it. So, yeah, I mean, when report is prepared and how it is to be done. The one, 212.15 is an important part. First time, SFIO's report, investigation report, of course, the earlier Act talks about that this is an evidence. The report is to be taken as an evidence, but here the significant change is that it becomes deemed to be a police report. That brings out a lot of, Junaid, I think that police report concept is going to make it, initial period, pre-trial period, that part will be straight away the framing of charges will start. So SFI has been given police powers in the sense of arresting a person if they have violated, making them these offenses a non-cognizable offense. At the same time, it's making the report prepared by SFIO a police report, which means we jump certain steps. So earlier, another distinction that we planning to have the special courts to have jurisdiction over these cases under the Companies Act. So coupled with these two, we can expect speedy trial under the new Companies Act 2013. This is about the new Companies Act has brought about provisions relating to foreign companies. It has been defined, and what is the scope of investigation, and they are laying down in 21711, laying down the procedures for getting information from outside. For example, it's a very typical problem we've been facing. The number of companies have made fraudulent schemes for collecting money from public, but it is completely internet-based. The moment they realize that there's a complaint against that company, so they disappear, and the entire data is lost because the website is gone. Data is lying in a server in US or elsewhere. So we do not have access to that, but this provision is, it's for protecting the interest of investors. This provision is going to be extremely helpful for us. 220 is about search. That's similar to 209 with slight differences between the two. This 447 is a definition of punishment for fraud and the definition of fraud. Fraud has been defined inclusively. It's a very, very wide definition. Two significant three rather significant aspects of this definition of fraud, that of course there has to be deception. Deception is an important element. And apart from that, there could be intention to have wrongful gain and wrongful loss. These are the two phrases which has been defined. Now, there may not be actual wrongful loss or wrongful gain, but if the intention was to deceive for the purpose of making wrongful gain and somebody is going to have wrongful loss, that is where it kicks in, this definition will kick in, and the punishment given is that public interest is shown that minimum, will be 3 years is the minimum, not 2 years. 3 years is the minimum imprisonment you have for if public interest is involved. So 447 read with 212.6 gives you a complete idea about that how to take care of your responsibility as a person responsible for compliance. I think I've taken enough time. No. I'll just take 5 minutes and finish it. Yes, sir. So this is an important aspect about 143.12, where the responsibility cast on auditors to report fraud. Because if it's not done, they're also liable. That's an important aspect. Rules to be framed, not many major rules. One is about the different specialization which we want to have. That's one rule. It's about arrest. Those are not very, so protection of employees during investigation. For if the company is requesting for getting investigation done, what cost to be borne. These are the details about the rules. So this is broadly about SFIO now. Under these provisions, these are the new powers given to SFIO. SFIO then had limited. Now it has been given substantial power with added strictness in the law to conduct investigation. Just quickly, the challenges ahead. Like we have an issue about regulatory landscape. There are a lot of legislations and there are overlapping legislation which create problem for an agency. So I think that the new provision for interagency coordination should be able to sort out these issues. Recently, an interministerial group has been formed with SFIO, RBI and SEBI. We've come across schemes which are thought to be CIS, collective investment scheme. SEBI thinks it is collective investment scheme. We might think it is something different, but these are to be resolved by way of interagency coordination. So that's a very important part. Of course, the regulations we are suffering from pehle aap kind of a syndrome. Everybody thinks that it's your turn to take it, but I think with proper interagency coordination, we should be able to take care of these issues. I think I'll skip these details about, I'll take 2 more minutes to finish it. I'll not go into details. Of course, we have issues about the substantial gap between detection and taking up cases for investigation. Because the fraudulent company, the life cycle is not more than 15, 16 months. And if there's a delay on the part of the government to order investigations, everything is lost. Public interest is badly damaged. So through interagency coordination, which is a part of 2013 Act, which should be able to help us to take care of these issues. And we feel that focus should be on detection, should be on prediction rather than detect. Detection is actually you detect, then you do a post-mortem. Slight change in the last. So we need to come up with facilities, methodologies for predicting if something is. So that is what we are making an attempt in SFI. We are trying to develop through data analytics. If we can predict that something is going to happen or not, that's going to help. Maybe we will be able to work with the companies, say that we have a suspicion and you are a responsible person for making compliance. So maybe we can work together to help take care of this issue. I'll keep this. Just one concluding remark I'd like to make, that there's a difference between de jure and de facto protection. That the Company Act is, or any other act for that matter, trying to, what they provide for in the act is the de jure protection to the stakeholders. But what actually de facto, what protection is giving, that depends on how we implement the act. That's how it's very important for us. Your help would be required to effectively implement the provisions of the new act so that we bridge the gap between de jure and de facto protection. And one small comment about the white collar crime and street crime. White collar crime is always, it's related to an occupation. It's by respected person of social status. Street crime is on the spot, it happens. You get angry, you pick up a knife and stab the person, but white collar crime it's more cold-blooded. It's more systemic. And it's done by people in high position and respectability. So that's, even for you, it's going to be difficult. If you find your CEO is playing mischief with the company, it's white collar crime. It's not very easy for you. You have to be tactful. I think we'll have to learn more soft skills than the hard skills, because you'll have to communicate that yes, there's something wrong, how to rectify that. So that aspect is important to understand. We are dealing with white collar crime, not street crime. So we're not going to work like police. We have to work like very tactfully with a lot of difficulties. We have to. I think with this, I'll conclude. Thank you so much for giving me the opportunity, and we hope to work together. Thank you.
Yeah, very well. Thank you. Yeah, friends, now the time has come for us to have the audience of our learned Registrar of Companies. Of course, we have already heard him about inspection investigation in the pre-SAR. But he is now going to deal with you the other part of, which is very, very important for all of us, and that is called compounding of offences, which is there in 441, and he's also going to touch upon adjudication of penalties as contained in 454. I think that is important. Why it is important? If by chance, as a compliance officer, as a key managerial personnel, if you fail to gauge the non-compliance aspects or promoters is doing something wrong here and there, at least you have right to go to the authority, plea bargaining kind of thing for adjudication of penalty. Power is there. You go for appeal if you are not happy with, to the regional director, next level. Get rid of and say thank you very much. Wrong thing, something goes wrong, may or may not be my involvement, but something that has gone wrong, oversight, not happen. But if you are not satisfied with this kind of thing, you have also opportunity for compounding the offences with the tribunal or with the regional director or so and so. That is very, very important for all the professionals, and particularly our profession. So not to have afraid of course I mentioned in the initial mark that you provide a platform where you should have a compliance check. If you do not engage yourself into non-compliance portion, no need to go to worry about this chapter 14. But chapter 14 is the friend, philosopher and guide for all of us. Because during the course of inspection investigation, or the compounding, or the adjudication, etc., you have to be a party to that, whether you are external or internal, whether you are a compliant company secretary in the company, or the company secretary in practice. You are one of the pillar, or you are the constituents of these actions. Therefore, it's very important. My friend, the senior has mentioned about that numbers. I mean, Juneja ji was mentioning during the discussion that numbers are very less now compared to the first one. He says that is the real people. Now they are now really going to now do work for the profession and the organization, because that is very important aspect. With this open remarks for the speakers, may I invite our learned Registrar of Companies, Shri Juneja, to speak on compounding offences and adjudication of penalties. First adjudication of penalties. All right. So yourself, now time is there for you. And your time starts
before
now.
Mr. Juneja comes for presentation, I acknowledge presence of Mr. Sanjay Verma. I request Mr. Deepak Ugreja to kindly present a flower bouquet to Mr. Sanjay Verma also. Representing OL office, Mr. Juneja, please.
Shri Nilmesh Barua ji, Director SFIO, Mr. Nisar Ahmed, Madam Ashu, Deepak, Ranjit, my dear friends, lo hum fir aa gaye. Right? After all that clinical examination and invasive examination, that is inquiry, inspections and investigation, now is the time for treatment. Right? So I am here with a capsule presentation. First an oral. This is an oral treatment. After compound we will go a little bit deeper on presentation. First just on adjudication. This is an oral treatment. A capsule presentation running over only 10-15 slides. This is a new concept brought in by the Companies Act 2013. Empowering Registrar of Companies for, reposing a faith precisely on the institution of Registrar of Companies for adjudication of penalties. So that on certain minor defaults, technical defaults, the so-called technical defaults, one is not, made to go through the rigorous of prosecution, go to the special court, stand along with all those Jeb Katras and other criminals. Just let the registrar initiate penalty proceedings and pay your penalties, either plead guilty, or if you are not satisfied with the order of the registrar, file appeals. So let us see how these provisions will be working. The enabling provision is section 454, which says that central government shall appoint adjudicating officers for all those offences where, sir, the word initial penalty is there. Let me clear this misconception that whether all fine, where the offence is punishable with fine or imprisonment or both, is not covered under this process. There are certain about 22 provisions in the Companies Act where the word penalty is there and which shall be covered under this chapter. But the adjudicating officer which the central government shall be appointing cannot be below the level of the registrar. And for this process he will be called the AO, that is adjudicating officer. The process will be, once the contravention comes to the knowledge of the registrar, he will initiate the penalty proceeding by issuing a notice, a written order to the company or the officer in default for non-compliance of that particular default, and give him an opportunity of being heard. This is in the, basically that process of natural justice has to be, an opportunity has to be given to the so-called accused, so that he can represent his case through himself or through the authorized advocate. Here is the area where I think that the profession of company secretaries shall be having immense, being the experts in the level of the corporate, in the field of the corporate affairs, where they will have an enormous area of practice. Sorry. There are appeal provisions also. Once, as far as enabling provisions are there, but I understand that the ministry shall be coming out with detailed guidelines how to deal with it, how to pass a speaking order, how to issue a penalty proceeding. Those things definitely will be there, so that the whole process of levying penalties is fair and transparent and just and equitable. So any person who is aggrieved of an order of the registrar, the AO, in imposing penalty, he can file an appeal with the office of the regional director. That appeal has to be filed within a period of 60 days. And the form and manner and all those things will be there in the rules. The regional director again shall give an opportunity of being heard to the appellant. And after giving that, process, after passing through that process, the regional director shall again pass a speaking order. He'll be having that authority either to reduce or to increase or if the technical process has not been followed by the registrar in the whole process, he can revert back the matter to the registrar to pass a speaking order and first complete all those formalities. So that means the appeal can be both on merits or on the technical aspects of the things. What are those areas, a few of them I have included in this presentation. What are those areas where penalty proceedings can be initiated by the registrar? The first is section 4, subsection 5, which says that in case of a name availability, the first step to incorporate a company is to get a name reserved. Now, if in this process it comes to the knowledge of the registrar that the name has been obtained by giving false and misleading information, by misrepresenting the things, and before incorporation of the company, this comes to the knowledge of the registrar, then he can impose. One step is, of course, to withdraw the name so that the incorporation process is stopped then and there. And the another is to parallelly initiate the penalty proceedings. And that law prescribes a penalty of, which can go up to the extent of 1 lakh rupees. Another is, now we all are aware now that under the new act, commencement of business is mandatory. Company cannot commence business or raise debts without filing a declaration with the registrar, that is for commencement of business. A declaration that all subscribers have taken their shares and registered office has been verified and things like that. So if there is a default in that aspect, this is also, the penalty can be imposed. And if there is a failure, that penalty can maybe extend to 5,000 rupees. And every officer who is in default shall be punishable with fine which may extend to 1,000 rupees for every day. One is the penalty to the company, another is the penalty to the officers in default. Failure to maintain registered office, which is a very common sort of thing. Section 12 now requires also the verification of it. So practically we are yet to see how many cases, whatever checks and balances now we have in the new Companies Act, that is verification of the registered office. It is not based only on the declaration, it is not based only on intimation, it is based on certain documents, it is based on verification by a professional. But in any case, if it so happens, if the company fails to maintain registered office, there is a penalty of 1,000 rupees for every day during which the default continues. But that penalty, of course, cannot go. The maximum limit is up to 1 lakh rupees. Alteration in every article and memorandum has to be noted in the copy. Every copy so circulated must contain what are the changes that have taken place from the incorporation of the company to till date. So there can be offences it can come to the knowledge of the registrar through suo motu or through some complaints that a copy has been circulated without including the changes that have taken place. For every offense, there is a penalty. So this is also covered under this process of adjudication of penalties. And every officer who is in default shall be liable to a penalty of 1,000 rupees for every copy of our memorandum or article so circulated without making any changes. And copy of the there is a now requirement that every copy of memorandum and article is to be given to every member whenever he applies for that. So if there is a failure to do so and complaint comes to the registrar, on one hand the registrar will direct the company to now give that copy so that the grievance is redressed, and at the same time initiate penalty proceedings, and then this penalty is leviable to 1,000 rupees for every day during which such default continues, subject to or 1 lakh rupees, whichever is less. So that means maximum limit is 1 lakh rupees. Public offer is to be accompanied with prospectus. So if it so happens, if there is a default, in complying with these provisions of section 33, subsection 3, a penalty of 50,000 rupees for each of that default. Requirement of minimum subscription and timely allotment of securities. So this is leviable with the penalty of 1,000 rupees for each day during which such default continues. Private placement, a new concept is there in the Companies Act, section 42. If a company makes an offer or accepts monies in contravention of this section, this section is very important because this penalty proceeding again is within the powers of the AO. Now the penalty is the promoters and directors shall be liable for a penalty which may extend to the amount involved in the offer. So we know that we know the quantum of defaults which have come to our knowledge. We have seen that quantum is up to 1,000 crore rupees, 2,000 crore rupees, 5,000 crore rupees. So this is the minimum penalty. I cannot reduce that penalty. Regional director cannot reduce it. This is the minimum. Yes. This is the minimum, right? Or to whichever is higher, or 2 crore rupees, whichever is higher. That means minimum is 2 crore rupees, and maximum can go up to the level where those funds have been collected, whichever is higher, and the company shall also refund all those monies. One basic concept, whether it is compounding, which we'll be covering later on, and whether these are penalties. There can be certain type of offenses which cannot be made good, like say jumping of red light. Right? So that offense is compounding the moment a challan is issued. This type of offense cannot be made good. The police wala cannot ask you to go back now and wait for the green signal and then only you can jump. The offense has already happened and it cannot be made good. Now there are certain type of offenses which have to be made good. The penalty, the offense cannot come to an end unless it is made good. So here, that is the concept which plays here, that one is a penalty, another is the money so collected has to be refunded. Okay. Publication of authorized, subscribed and paid up capital together. आज सब लोग लिख देते हैं कभी, so only information is given only with regard to the paid up capital and authorized is not given. Any money collected beyond authorized capital is ultra virus and it is a matter of contract between the two parties. The other party must know what is the authorized capital, what is the ultimate limit with the company, the extent up to which the shares can be issued. So the law now requires for larger dissemination, and basically this provision is in the interest of the investors, that they must have knowledge that all these, what is the authorized capital, what is the paid up capital, what is the subscribed capital, so that all those things are clear. And if a default happens, if this publication together is not given, the offense is punishable with a penalty of 10,000 rupees, and every officer of the company who is in default shall be liable to a penalty of 5,000 rupees for each default. Or to close register of members or debenture holders, other security holders, and time limit for the same. This is under section 91, subsection 2. And the offense is liable with a penalty of 5,000 rupees for every day, subject to maximum 1 lakh rupees during which the register is kept closed. Place of keeping and inspection of registers, returns, etc. The law gives power, a right rather, to the members to have inspection, take copies. And if these things are not kept open, the place is not known, the offense is punishable under 94 subsection 4. And penalty is 1,000 rupees for every day, subject to maximum 1 lakh rupees, during which the refusal or default continues. Circulation of members' resolution is penalty of 25,000 rupees. Minutes of general and board meetings, the penalty is, company is liable for 25,000 rupees, which is the minimum fine. And every officer of the company who defaults shall be liable to a penalty of 5,000 rupees. Inspection of minute books of general meeting, if it is refused, then the penal provisions are there. The liable to penalty, for a company 25,000 rupees, and for every officer who is in default, liable to penalty of 5,000 rupees for each such refusal or default. Right of the members to have copies of the audited financial statements. And if it is refused, the penalty is 25,000 rupees to the company, and for each officer shall be liable penalty of 5,000 rupees. Similarly, minutes for the board, 173 subsection 4, there are penalties. Register of contracts or arrangements in which directors are interested, contract of employment with managing or whole-time directors, all those penalties shall be adjudicated by the registrar. Thank you very much. This is a very short and crisp. 22. There are 22 such.
I think you'll take up this compounding also.
No. Any questions on this? No. Minimum penalties cannot be reduced, of course. Minimum is minimum. Law prescribes that minimum no one can reduce.
Hold your questions for the 10 more minutes, 15 minutes. Let him present the compounding part. Because both are very, very important to understand. And then when you go back, you have complete picture about
this
what is adjudication.
Okay.
Yes, please go.
Was supposed to be given by my colleague Mr. S.B. Gautam, official liquidator, and jointly by Mr. Sanjay Verma. Unfortunately, father-in-law of Mr. S.B. Gautam had a heart attack, so he had to rush to Lucknow. So whatever I am speaking is speaking on his behalf.
This is a disclaimer.
Not so statutory warning.
Disclaimer.
My dear friends, as I said in the first session, that there is a very thin line between a technical default, an honest mistake, and a fraud. The law understands this thing, and depending upon the level of the offenses, like in the 1956 Act, the provisions of compounding are there, notwithstanding the provisions of compounding in the CRPC. There are various types of offenses, punishable offenses under the Companies Act. One is an offense which is punishable with fine only. Another is an offense which is punishable with fine or imprisonment. Fine or imprisonment or both. And the third is punishable with fine and imprisonment. Very briefly, the offense which is punishable with fine and imprisonment is not compoundable. One has to pass through the process of prosecution. The offense which is punishable with fine only and the offense which is punishable with fine or imprisonment or both are compoundable offenses. This law has already been settled. Third issue, before going into the presentation in detail, there are certain basic ingredients for compounding. Compounding is a matter of settlement between the complainant and the accused. That is why there are provisions that since all offences, all prosecutions are filed by the registrar as per the scheme of the Companies Act, and by now these will be filing by earlier also, SFIU has also been allowed to file.
Earlier they used to file.
Right. But the law says that compounding application has to be filed only with the registrar. And he'll forward that compounding application to the competent compounding authority. Now, if that particular offense or that particular violation which came to the knowledge of the registrar or for which the compounding is filed is suo motu, that is only between registrar and the accused, then he can decide on the basis of whatever record out are available, what is the nature of the offense, what is the matter on record. But if other agencies are also involved, like if a matter is arising out of an investigation from SFIO, the registrar is duty bound to first seek a no objection or comments at least from the office of the SFIO that this offense came to the knowledge, this compounding has been filed on the basis of offense which came to the knowledge after investigation which was conducted by the office of SFIO. Compounding application has been filed. This is the copy. So please offer your comments so that along with your comments, along with your recommendations, whether you agree or whether you do not agree, this can be forwarded to the competent compounding authority and similarly for other departments. To make any offense as agreeing to compounding, before agreeing to compounding or before reaching to a logical conclusion, the offense must be made good. If the offense is continuing in nature, right? Unless the offense is made good, it cannot be compounded. I cannot agree to compounding. The first thing, which I have to examine from my records is, what is the nature of the offense? Whether at all it is compoundable? If yes, what is the nature of the offense? Who are the people involved? Name of the company, the officer in default, the relevant period of the default, when this offense had happened, whether the compounding is from the persons who are the accused, things like that, all those factual informations, and whether ultimately, since the offense, whether the offense is in continuing nature, since that offense has been made good, and it can be compounded, then ultimately on the quantum of compounding, there is a matter of hearing, and it happens during the course of those proceedings. In nutshell, सारा कुछ बता दिया मैंने. Let us now go through the presentation. Sanjay, correct me because this was prepared by you. If I drift here or there, please correct me. So, offenses under the company that they are compoundable offenses, non-compoundable offenses. Fine only, all those things, regional director. No, fine only and fine does not exceed 50,000 rupees, 5 lakh rupees.
5 lakh.
Presently it is 50,000 rupees. If the fine is only up to 5 lakh rupees, the competent compounding authority is the office of the regional director. The offense is punishable with fine only, and fine exceeds rupees 5 lakh rupees. Then it goes to NCLT, National Company Law Tribunal. Imprisonment or fine or both, then this compounding can happen only with the permission of the special court which shall be constituted as per section 435 given in chapter 28. And of course, the offense where there is a mandatory imprisonment, offense cannot be compounded. Okay. Any offense covered under this section by any company or any officer shall not be compounded if the investigation against such company has been initiated or is pending. Compounding can take place only when investigation has already been completed and report has been received. If the investigation is in process, it has been initiated or is pending, then that offense, particular offense, cannot be compounded. One has to wait for that investigation report on that. That offense, once compounded under this section, similar offense, for example, one compounding is filed for non-filing of balance sheet in the first year. Second year, again there is a default, and he again comes for compounding of offense. In the 1956 Act, there was no bar. The only bar said that similar offense cannot be compounded in a period of 3 years. Now the law says similar offenses committed subsequent to the date of compounding of the first offense can be compounded within a period of 3 years from that date, and then fine shall also be double the penalty already imposed. In case of company, the composition fee shall be paid out of the funds. अब क्या होता था कि compounding is charged and the officer normally gives a declaration that this is being paid out of my own pocket, but ultimately when the balance sheets are scrutinized, it is seen that has also been charged to the profit and loss account of the company. Now the law clearly specifies that a compounding fee charged to the company can be paid out of the funds of the company, but the compounding, to the officers in default has to be paid out of their own sources, own pocket. Every application of a compounding shall be, of course, filed to the registrar, who shall forward the same together with his comments to the tribunal or the regional director or any officer authorized by the central government. Once the offense is compounded, like now, even now, after a compounding order is passed by the competent authority, the copy of that order is filed with the registrar for registry purposes on prescribed Form 21. Now the law prescribes that within 7 days that intimation has to be given to the registrar so that this information is there in the registry for public information. Okay, achha. Anyway, these are now, my dear friend has listed all those, this is a very big presentation. All those provisions are there which are compoundable. Say 11.2 is compoundable by regional director, 16.3 is compoundable by regional director, 26.9 contravention of provisions relating to issue of prospectus is by regional director because of fine is less than 5 lakh rupees. 53 subsection 3 violation of provisions relating to issue of shares at discount. 56 subsection 6 failure to comply with provisions relating to transfer and transmission of securities like 113 today. 59 subsection 5 committing default in complying with order of the tribunal relating to rectification of registrar members like section 111A today. Okay. 64 subsection 2. Failure to file a notice related to alteration, increase or redemption of share capital along with the altered memorandum with the registrar like Form 5 today. All information with regard to all changes in the authorized capitals are to be filed with the ROC. If there is a failure, that offence is compoundable. If a company makes any default in complying with the provisions of any section. So these are all those sections you can easily. Should I go in detail all these things? No. Okay. Sanjay, anything else here? इसमें कुछ है और? Compoundable by tribunal. Okay. Okay. In non-compoundable, there is no point in discussing all those things in this session.
Yeah, I will mail to you.
Yeah, sure.
Okay. So it is better if we take questions on these two small topics, right?
So thank you very much, Mr. Juneja, for having given this, morning and then evening second session on this inspection investigation in the first part and how to mitigate those inspection investigation outcome by way of adjudication of penalties and also by way of compounding of offences by the tribunal or by the regional director as the case may be. So now is the full bouquet is now there with Mr. Juneja. Of course, in between we have a regulator who is going to be the independent than of what today regulator perceived to be SFIU. The SFIU today perceived to be a part of, 235, 237 actions. But now tomorrow after this particular action 206 and particular 212 is going to operationalized, SFIU is having a power of under CRPC, under IPC, all the powers are there with them. And the report would be treated as the report to the court and based on which the court is going to adjudicate the matters and impose penalty or imprisonment, etc., etc. Maximum matters, if you look at this, 360-degree for filing of the SFIO about the corporates, not SFIO, but is the corporates that is being done. One thing I made a request, to our director SFIO, who is now joint secretary, to please look into this matter of propagation, education, this idea, this chapter 14, particularly 212, this required to be taught to all the professionals and maybe some institutions are there, chambers are there. So maybe, this require a kind of interaction to create awareness campaign. That's very important. But the idea is to, let the people to be educated, to not succumb to this kind of provisions, particularly which we refer to 2126, subsection 6, which we are referring to, and the all penalty and prosecution part. Simultaneously, if you look at this, let me, before we start the question answer, let me conclude it, by putting the word charity begins at home. The old saying. And the governance begins at the board level. So governance with the board. So charity begins at home, governance with board. Please remember this message this is the takeaway from this second session of this technical session which we are going to back. And board, who is there? We are the one of the major constituent of the board composition. Of course, members are there. You are not a member secretary, but definitely time will go. You are now upgraded to be called a KMP, part of KMP. You means this all our profession. But definitely there is a move. Other jurisdiction has started now looking company secretary, whether South Africa, UK, Australia, Singapore, started looking company secretary as a member secretary. Necessarily the member secretary means the person should be on the board member. So time is there after a gap of 10 to 20 years or 30 years, you are going to upgrade your skill. Here is a responsibility because your action is being under public scrutiny. I'm not frightening all my colleagues sitting here or those who are not here through webcast, they have been now connected with us. Our action is under public scrutiny, so as to our board members' action. In totality, as a professional, because I am addressing today the members here, professional members, the society is looking at the professional to be a kind of, person who is having impeccable record to comply, nothing but comply. And to avoid all sorts of, unpleasant things that is happening in the organization tomorrow to safeguard. And here is the role, the public scrutiny means that your punctuality about the compliance regime is very, very important aspects. No secrecy to be maintained. Be transparent. Whatever you are doing, because the Companies Act 2013 provides for every company, particularly all listed companies and other companies have to have a website. All corporate actions are supposed to be put it there, code of conduct, etc., etc. Risk management, risk mitigation processes are there on the website. Then secrecy to be, what secrecy you are going to have, not to show this document, that document should be avoided now. And exemplary ethical standard to be displayed by particular profession called company secretary. And if you are there, your public scrutiny, you are going to have the outstanding remarks by the public at large, regulator at large. And therefore that's very important message we are going to take from this technical session. The third one is I am going to raise, friends, that compliance. The word is very important and dear to all of us. And the compliance denotes is a basic tenets of the governance is the compliance. So governance means if you comply the provisions of law as laid down by the legislature or by the regulators. Here is the requirement of governance of compliance certificates. That is another important part. How you are having genuineness of the compliance certification which you are going to give it to, or validating as an in-house counsel or external company secretary or the professionals associated with the organization in validating the actions which is empowered to be done by the statute under section 92 or elsewhere. I am not referring so many sections where you have to have validation from internal and external professionals with regard. The genuineness of the compliance certificates are going to be under public scrutiny, both by the public at large and the regulators in particular. Plethora of laws you have to see. If you look at this chapter number 13, and I will request you to please go back and see the rules made under chapter 13. And if you look at this rule, you will find 13.7 particularly, which talks of compliance of various laws applicable to company, to be validated by a professional called company secretary. 13.7 talks of 9 major acts, and it says other sectoral laws applicable to the company or any other laws as may be prescribed by the government from time to time to be followed by the governance professionals or company secretary. Therefore, this very important aspect of the takeaway further here is the genuineness of the compliance certificates and the laws which are applicable to a corporate to which you are associated as an internal company secretary or external company secretary should be complied with, and you have to give a kind of certification. That is very important. Now therefore there is an important message from all of us here sitting that use of professionals' acumen and integrity, you can say this honesty, probity, visionary, prudence, execution astute financial management, and moral turpitude. These are the words not there in the dictionary. These are the dictionary words to be required to be now practiced in later in spirit. And then only you can say, I'm a governance professional. I'm a person to be known to be the world at large, that look, wherever I am there, organization is benefited with my vision, my understanding, my thinking of law, my impeccable record of compliance of the various provisions of law. And there you are getting benefit to the other stakeholder. Because large pool of stakeholders, they are not there in the organization day in, day out. But they are their external investors, your supplier, your buyer, your employees, and so on and so forth. I don't want to deal with too much. So this is another very important aspect. Now I mentioned in the beginning of my remarks, the board processes. I repeat again, because very dear to each one of us in the core of heart, when you are not talking board processes, that it's the company secretary who is a custodian of board processes. Please ensure, discuss with the chairman, CEO, and other working directors in the organization outside the boardroom, discuss the processes to be aligned with the spirit of law that has been now as a part of the statute book. It is no more now debate as a company's bill, which we have been discussing 97 or 93 onward. Today we are now having a bill that become converted into an act, and tomorrow you are going to practice whole 470 sections and 7 schedules. Therefore, please discuss outside boardroom a kind of platform how you are going to typically let down the principles of compliance and also board processes. Transparency through internet, because the timing is very important. This is because everything is to be there in the blogs and the website. Your internet is going to be, you are going to communicate as a compliance officer, as a key managerial personnel. So these are the words I would like to share with you at the time of your discussing the two regulators sitting here. One is there, 2126 is talking to cognizable offense. Meaning thereby, if you are trapped under the nuances of these 15 actions, corporate actions under 212 subsection 6, these actions are cognizable offense, meaning thereby that you have to be put behind the bar. You would be arrested, you will be produced before the magistrate in 24 hours time. If you have been arrested in Timbuktu, you will be produced there in the magistrate before the Timbuktu and get a transit remand. If you happen to be in Delhi, but arrested in Assam, you will be back here in Delhi after arrest, after putting this. These are the process that SFIO is going to deal. He has very softly not dealt with that hard portion of SFIO, which typically is going to perform the duty of police to arrest. In case of fraud is being now instituted, and the people, those who are associated directly or indirectly with fraud, to be nabbed with this kind of, this is a cognizable offense. He has also mentioned about 6 months minimum imprisonment in case of these 15 actions you are trapped in this section which are there, the actions, non-compliance of those questions. And that penalty would go, and the imprisonment would go for 2 years minimum. 3. In case of 3, in case of public, outcry is there and public interest is involved. At the same time, so one really has to see, as I mentioned, he has already started his lining that, look, you gentlemen are going to be the neighbor of mine jurisdiction. He started with these words, neighbor of my jurisdiction. My jurisdiction has started, 14 has started 206 onward. But 205 end with the function of the company secretary. 203 talks about the key managerial personnel, appointment of company secretary. And 204 talks about secretarial audit. So 203, 204 and 205 solely dealing with the company secretaries, and they start with again inspection, investigation and prosecution that start 206 onward to 229. So I think the message is very clear, sir. Thank you very much and for all these things. Mr. Juneja has also, he has been now dealing with, I think time has come for all of us. I'll stop here for the time being. If required any question, I will answer. But definitely you have a lot of questions from the audience on this, both our regulators. One is super regulator in the form of SFIO. Another is your friend, philosopher and guide. He's also going to adjudicate the matter as a registrar adjudication. He will also play some role of tomorrow as a regional director compounding of offences. You go before the quantum is up to 5 lakhs rupees. So he's a friend, philosopher or guide. He is not going to be a friend, philosopher or guide if you're trapped in 2126. He's going to come. Let the court to decide the matter. So here is the open house for all of us to have the lot many questions. I'm having any apprehension you have about any subject that have been now discussed today in the second half. Please raise your question, put your name yourself and address whom you want to address the question. Now house is open for. Yes.
Yeah. I'm Rajesh Arora this side. My question, any one of you can basically just let us know on this. Once this company law is, whole company law is, notified, then these sections would be effective retrospectively or prospectively. Reason being, give you the example. Say for some non-contravention happened in 2009 and it is revealed in 2014 that there was a non-compliance. Which act would be applicable? Companies Act 1956 or this new act?
What is your preference?
Okay, you are a friendly atmosphere. You raise question. Yeah.
Sorry?
What do you prefer? You want 2014?
Retrospectively, you want...
See, in my 20 years of careers, I have never come across any kind of, proceedings, non-compliance kind of thing. So, my preference...
Sir has rightly asked, what is your choice?
So...
Hold on. Okay.
Sir, section, may I?
Yeah, please.
Section 447, 448 and 4, they have already been notified. 447, that is punishment for fraud, has already been notified.
12th September.
On 12th of September 2013. Like section 185 has already been notified. But to my understanding, this is my personal opinion, that no law can be, of course, retrospective. Any offense committed from this date onwards, from 12th of September onwards, right? Then there is no other section other than 447, 448 and 449. By file prosecution, if the commence comes to knowledge today, but it happened before 12th of September, while filing prosecution, definitely will be writing that this offense was committed on so and so date. This was the period of default. These were the officers in default. And the relevant section at that point of time was 628 of that Companies Act 1956. And from this date onwards, if the offense is continuing in nature, let us say if the offense is continuing in nature, then of course, both these things come into play. And then it will be at the prerogative of the court when they award punishment.
Second one is just an observation, MC notification. They are basically recruiting NCLT members. I've seen that advertisement. In fact, I was waiting for that advertisement to come in. I'm really surprised to see technical member, qualification, chartered accountant and cost accountant. This is, I don't know whether someone is there from MC or not, but this is a request from the member side to the institute that they should raise up this matter with the institute, MCA. For technical member, chartered accountant and cost accountants, CS is not there. For judicial members, retired high court judge, and advocate in practice for more than 10 years, like that. So what I mean to say, company secretary is there, not there in NCLT.
I think you have forgotten to read the word company secretary. It is there. Okay? You have forgotten to read. Go back and read and then call me in the evening.
Right.
It is there. Don't worry. It is there. All right. So answer is yes, all three professional brothers are having 15 years of experience, are entitled to apply. I hope a couple of, out of 14 posts for technical members, I think 4 or 5 company secretaries are expected to be there in the, if everything goes well. So 15 years experience are there. So don't worry. It is there. So not to worry.
Sir. Excuse me.
One question here and then you raise question. Yes, sir. Yeah, please, Brahmani, sir.
Just like to have your personal view on the scheme of things that when you were addressing, you said ki it is your report. When you have made a report, have done the investigation, then you are submitting that report to the government. On that, a legal opinion is taken, and then it comes back to you whether to launch the prosecution or not. Are you happy with the scheme of things? Because whatever good work has been done, that could be eventually undone, as we have seen in case of many politicians, other hypocrites who are not sanctioned prosecution. or in whose cases prosecution is not sanctioned. The other is, perhaps both of you can address, the other is where you said the preliminary inquiry is out of your jurisdiction, he does the preliminary inquiry, and if he comes to the conclusion that it's not a fit case, then that case doesn't come to you. Tomorrow, if it is found that it was a very serious offense, naturally that call has to be taken at that appropriate time, and whatever opinion is found by the ROC is based on the material available before the ROC. But are you happy with this scheme of things, or you feel that this jurisdiction of inquiry should also have been in your domain?
Of course, personal choice doesn't matter. It's the law which prevails. But you see, I had a very frank discussion with one of colleagues who was with the minister a few years back when this whole concept was started. He was telling me that, I'm just sharing my listing, that he was saying that why giving a sanction against a company has to go up to the minister. It's the minister who gives a sanction to investigate also. Now, of course, it has been broadened now. See, probably the purpose behind that's what I'm just talking about our discussion. He said that sanctity of a company as a business entity is something, it's sacrosanct. I think it's over evolution over a period of time. That company is an entity that it has the limited liability, all those issues. So I think idea is not to kill a company very easily, because a report, a strong punishment can lead to a liquidation of a company or a winding up a company. So I think if you read MCA's that vision, it talks about enlightened regulation. I think the spirit is enlightened regulation. So that's why there's so many checks and balances. Even while giving the power of arrest to SFIO, there'll be a lot of checks and balances. I think every step the government has tried to, because ultimately the purpose is, that's the engine of growth, company. I go by the spirit. If we are talking about enlightened regulation, we need to have a lot of checks and balances so that we don't try to overkill. That's my personal response. I'm a business management student. Probably I'm looking at it from that perspective. The second part, I think there are certain shortcomings in the earlier. Now, if a case is very urgent and the process of going to the ROC's report, it might take time. So I think that's why they have brought in 3-4 other elements now. And that's how when you're talking about public interest, suppose money has been siphoned off by companies that people are, investors have lost money. We have been facing a parliamentary standing committee that where was SFIO when all this happening? We did not have that kind of a role. So we clarified that SFIO's role starts when the reference comes. But at the same time, slowly we are trying to evolve that it could be playing the role of an oversight agency also. That is where we start talking about some kind of a prevention. And that's how the whole inter-agency coordination comes in. Because, to give an example about all these so-called cheat fund cases, now what is happening in all these cases, investigation comes to us at a much later date when everything is over. First agency who comes to know about this is the police agency, state police. And there also, when people are getting money back, initial period, first 12-15 months, everybody gets the return, very good return they get, so everybody is happy. It happens when the flow breaks. So the inflow is less than outflow, that is where they stop, they abscond. So we are trying to have an interagency coordination whereby we will work together, at least we'll be able to spot if state police informs us that yes, we have started getting FIR now. So maybe the government, by expanding that when a case can be referred to SFIO, by increasing the number of channels to more than one, even the company can tell us now by way of a special resolution. I think in both these cases, we are moving towards a more mature regime than what was there before. Thank you.
Taking that forward, taking it forward, in the case can ROC making inquiry reports. I don't think that's been referred to SFIO. Why is that?
No, it has not been. Actually, it's being done by RD. Sorry?
That's what I understand from Minister's statement.
Yeah, it's not been referred to. Though initial part when it's of course in the public domain. Sorry. When initially the issue came up, NSCL, definitely I was part of the committee with Director, Enforcement Directorate, where we given a report at what should be the line of action. And that's why the government has gone by that line of action. And then that's why RD has made this basic, that inquiry has been, that the inspection has been done by, that's an inspection or?
Inspection.
Inspection has been done by RD. And the other agency, actually the whole concern of NSCL was how to protect the interest of investors. When SFIO comes in, protection of investors, we cannot protect the investors. It's like ED, for example, if there's a crime, so under certain crime, then that proceeds of crime can be frozen by ED. So that's why very carefully the combination was done. Who will do what? EOW did a lot of work in Bombay because they could immediately get into action. Income tax could do little because they went for survey, search operations, but there they were looking at income. So that was not there. So the government has taken an approach, multidimensional agency approach, to find out how to quickly to stop this and help the investors to get some money. I mean, that was the call. I'm just sharing that definitely SFI was part of the initial committee. But no, it's not, but inspection has been done and then by.
No, all right. For the action taking report for internal documents, actions are now being taken. You know, FMC has already, taken a decision based on certain inputs from the regulators, various regulators, You want to say something for this, Mrs. Birwani's comments? All right. Yeah, you have a question down. Yes.
Agency C and identify the responsibility of other persons other than company secretary. Is there any person in the organization or not? And what precaution or what course of action should a company secretary should ensure to mitigate this responsibility thing?
Thank you. I think you raised this question in the very first part also. I think you are repeating the same one. All right.
No, not repeating, sir.
Your concern is genuine.
Secretary, I am company secretary.
Look at. So, I have already understood your question. Yes, I heard you also in the very beginning of the first technical session.
Sir,
let me tell you. Why company secretary should be held responsible? Because law required to do so. Law is require a person who is called now key managerial personnel for compliance, and there is, if you look at this, read carefully all these sections. Section 2, subsection 47.
No, sir, what compliance officer definition is given?
Unless you hear me, you will not get the answer.
No, sir,
you have raised the question, I'll answering you.
Definition of compliance officer has not been given anywhere. I think company secretary definition has been given.
Please listen to me
that the ministerial duties kind of
thing.
thing.
He's not trying to listen. Read, I'm sharing something. If you have patience to listen, Section 247 provides for, you are part of that, then read with 205. 205, 203. Now, 205 is the function of the company secretary. And one of the function of the company secretary of the company, I'm referring to for the time being. 204 I will discuss little later. 205 says one of the function is, the first one is to ensure and to update the board about the compliance of Companies Act and other laws applicable to the company. It is the Parliament has now debated this issue, and then you also ensure the standards, secretarial standard, and third one is talk about all other functions have been prescribed. Under this chapter, that is 13, I mentioned to you during course of my intervention and my updations on the subject, I requested each one of you to please read these rules under chapter number, draft rules at least, not rule is not yet been notified, but draft rule is there in domain. If you look at chapter number 13 rules, you will find the list has been expanded. What is expected out of a company secretary to perform his or her function vis-a-vis the company? And duties are now there, list is now there. So please understand, and to perform that list, you have to seek aid and assistance, create a department, have the diagonal, whether internal or external team, your management has to provide. If management is not providing, alone company secretary. But as far as non-compliance of various laws are concerned, there is a way internal. You discuss this issue in the board. As a compliance person, for listed company, company secretary is a compliance officer. But beyond compliance officer, 7 level beyond compliance officer, you are KMP now, key managerial personnel. Along with the CEO, you are clubbed together. You cannot run away from your responsibility not to update the board about the compliance of various laws applicable to the company. Now, how to do it? How to do this method? It is an internal debate. You have to create a department. You have to hire the people to look, somebody to look this, some different law. And you have to take internal and external validation. Yes.
Companies, particularly those listed are joint ventures, they have this departmental heads, the board resolution is passed where the individual is made responsible for compliance. Like the CFO gives compliance about service tax, whether the loan has been paid on time, income tax, blah, blah, blah.
Not run away from the responsibility or not to do.
Administration is there, labor
Yes, yes.
laws compliance. So that is the way company secretary can save himself from being prosecuted for any offense committed under any act, other act. So that is also being done in companies where the resolution is passed, the person gives his consent that he will be responsible. That is where it is done. In some companies, just the compliance certificate is paid, the board does not pass the resolution. What should be done is board should pass the resolution, take consent of that person, and then that person can be made responsible. That can give you some protection. This particular person was responsible for compliance with that particular.
All right, we continue to discuss this issue.
I am A.K. Bansal. I happen to be Group CFO and Company Secretary of a 2,000 crore plus company. That is a listed company. I'll give the answer of this gentleman, and it is in line with the just answered. In our company, we have done the same thing. What we have done, we have passed a board resolution responsibling, be it HR head or certain operational people or certain administrative people for different kind of activities, so that right from the day one, the responsibilities are duly, assigned to respective persons. In this dynamic world, one person individually cannot take care of so many laws and legislations. And what we have also done additionally, in case of every quarterly board meetings, we are taking certificates from respective SBU heads, CEOs, as well as HR head, as well as other operational people. And based upon that, I, along with CEO, that is MD of the company, place that certificate before the board for their final perusal. I think it should be.
सर जी
Yes.
हम लोग
Regulator.
शेर पे बैठना भी चाहते हैं और शेर से डरते भी हैं. So we must learn how to tame the tiger. Either first we have a desire, to ride the tiger, then we must learn how to tame the tiger. That's it. 2 लाइन में सारी बात समझ जाओ. That's it.
Hello. I am Kamal Goel, PCS. These days, I have been getting some emails, one from SEBI, of course, circular by other our fraternity, and then other for that about that lack on the part of the professionals. So that means our institute will have to do something to make the people aware. One thing was from SEBI that 1100 listed companies, they are not, sending that their reports, etc. properly. Most of them, the work is of that company secretary. And the second was there that the professionals, they are submitting so many papers. Most of them either wrong or something they said they have kept bank, etc. So I think our institute will have to instill a sense of real thinking that this cannot work after that our 13 comes into operation. So for now it was there, nothing, some conductor will be there, nothing is there, nothing will happen. So people were just under that impression. But after once, all that our comes into operation, all the clauses, all the sections, then it will be really difficult for the company secretaries to be able to withstand all that pressure from that our regulatory bodies. Second thing is, regarding our regulatory bodies, I have in that following case of that Sahara. So far all that cases there regarding valuation. Now they say they have valued that 20,000 crore. According to that the Supreme Court and all that also may not be even 1,000 crore, something like that. So in that case also our values, etc., they are not performing well. And unless some real punishments are given, we will not be able to say improve the quality of our professionals. And similarly, Sahara, they are sometimes going to Supreme Court, sometimes they are going to SEBI, then after SEBI again they are going to so, then probably it is of course a wider issue which has to be tackled by the government. I think our institutes cannot do anything also. These are 2 or 3 aspects. Ultimately, if we really want to improve that governance so that there are less offenses and all that, so that way this is very much essential according to me. Thank you.
Any other questions, or can we wrap up? I think Institute is doing and continue to do. Institute will not run away from its responsibility of educating or asking this capacity building program. This is one of the program. We are having regular classes in CCGRT on residential basis for updations on topic wise. And if you look at this, go to the website, see this, all 3 months calendar is there, our research center. And there we have around 50 members at a time can participate in classroom kind of thing. There people are coming from IIMs and other places, and we have regular classes going on there. So one really has to spend some time, take sabbatical leave for a 1 month education leave for a 1 month and get himself updated. So it is there, possibly there. Sahara matters we will not discuss here, but definitely it's a matter of concern. Definitely it will come once it is concluded in the Supreme Court or SEBI tangle. Maybe we will see this, what is the outcome. But one thing is there. Mr. Juneja has touched upon in his morning session private placement. And it is just not coming from the investigation or the experience gained during the course of SEBI and other places, high courts. Now the government has now that there is a law that if you want to do private placement, you are allowed to do so, but you follow the rule of the game. And if you don't do it, here is the requirement for adjudication, and then you have penalty. The amount which you have collected, you have to refund, or 2 crore. In addition to the amount which you are going to refund, the penalty would be equal to the amount which you have collected from, private placement, or 2 crore, whichever is higher. So this is the, quantum, and it's called severity, this part. So I think this message is very well clear. These all matters which is there in public domain are being now discussed while formulating the Companies Act 2013. It is a very fresh act, taking into consideration whatever has happened in 2011, 2012, up to 2012. This matter has been now taken together, and now today we have, but no law is static, it's an evolution. As we grow further, we have the power to, change the rule of the game. The government is now competent to do so in times to come. So I think let us now, wait for the new Companies Act fully operationalized in a month's time or 2 months' time. Whenever is going to, government has some time frame to start with. We have 98 sections in public domain. We have to follow the rule of the game with regard to 98 sections. But with regard to other sections, we have to wait for the rules to notify. Concurrently, the sections are going to be notified. So I think the government is working very hard. It will come in a month or 2 months' time, or maximum 3 months' time. So, but we gear up to embrace these new provisions of law and take it forward. And that's the only way to, live with the new regime. So this is the message, and any other question, then we say conclude. I think if there is no question, so conclude, Mr. Chairman.
I think we should conclude. Since morning we are here and listening from all the senior faculties. First of all, I'll convey my sincere thanks to Mr. Nisar Ahmed for chairing the session very wonderfully. Dear friend, one message we have got from all the London speaker and even chief guest today, that new law in place and we have to realize our position. The act is there. Now we are in the bracket of Company Secretary, KMP, and we have to relearn the entire law to give quality services to the industry as well as regulators. Since morning, Mr. Nahata, who was chief guest, then Mr. Harish Kewed, vice president, Mr. MS Howe, discussed about the governance. There are various new concepts which has come under the new Companies Act, which has strengthened the governance of the corporate. We have to understand, we have to relearn it. That's the message we are getting from today's seminar. I convey my thanks to Munit Chaudhary, our program chairman, PTC committee, for designing this program. As Mr. Nisar was saying, the governance and fraud, both topics have been combined. Why? Because there is thin line between both the topics. If there is non-compliance, it's fraud. If there is no fraud, it's governance. So thanks to Vineet for taking this initiative and organizing both the topic simultaneously to understand better for the members. Now I request my council colleague Ashu Gupta to propose a formal vote of thanks. And I also thanks to our NIRC team, Mr. T.R. Mehta, because there are a number of programs we are organizing. As Mr. Nisar said, SCCRT, they are going to a master class. We also at NIRC organizing workshop, every month workshop on particular chapters, so that we have a detailed discussion on that particular chapters and section. Thanks, sir.
Shri Nilmesh Barua, Director SFIO, Manmohan Juneja ji, Registrar of Companies Delhi and Haryana, Minister of Corporate Affairs, Mr. Kukreja, Chairman NIRC, Mr. Nisar Ahmed, Past President ICSI, Ranjit, dignitaries of the dais, my learned professional friends, ladies and gentlemen, good afternoon. Now we are at the end of the second technical session, and in fact at the end of this today's seminar, talking about governance, fraud and offences. Yes, Nisar Ahmed ji was very correct in his opening remarks that he has said we at NIRC have tried to cover these two topics in the presence of regulators to understand their perspective, their point of view and their expectations for professionals like us. Now we have to take it forward. We are here for the implementation of Companies Act 2013. I, on behalf of NIRC, place on record my sincere thanks, firstly to Shri SP Gautam ji, official regulator in absentia, for the wonderful presentation, which was carried over by Shri Manmohan Juneja ji. Thank you very much, and please join hands for Shri SP Gautam ji. I place on record my sincere thanks for Shri Nilmesh Barua ji for sparing his valuable time and talking about the function, role of SFIO. I invite Shri Ashok Tyagi ji to come forward and present a memento. As a token of our love and respect, thank you very much, sir, for sparing your valuable time. We are indeed grateful, sir. Please join hand, friends. Friends, I'm sure no one among us can understand the nuts and bolts of Companies Act 2013 and the legal issues that go with it better than Shri Manmohan Juneja ji. He was sharing his views since morning. He was with us. Thank you very much, sir. We are indeed grateful. And Nisar ji was very much correct in saying that he has always been a friend, philosopher and guide for all of us. During our professional career, I am sure each one of us sitting here has got an opportunity to interact with him during his professional assignments. We are indeed grateful to you, sir, for always being a support, and we look forward for your patronage in future also. Thank you very much, and I request Shri Vinod Goyal ji to come forward, a senior member, to present the memento to Shri Manmohan Juneja ji. Thank you very much, sir. We are indeed grateful to you. Thank you, sir. Now, the protocol we cannot offer memento to Shri Nisar Ahmed is part of us, but we are indeed grateful to you, sir, for summing up this session, not only the second technical session, but the whole today's discussions for during the day. Please put your hands together for Shri Nisar Ahmed ji. Thank you very much, sir. We are indeed grateful to you. And now I'm indeed grateful to Vidit for organizing this wonderful program, and to Chairman NIRC and all the chapters who've been connected with us during the day. Thank you very much. In fact, I am thankful to each one of you present here for making this a program grand success, and probably this is our last program for this 2013. I wish you all a very happy and prosperous New Year 2014. Thank you very much, friends. And do join us.
Not last, we have annual dinner. This is the
professional
New Year
program.
celebration.
I'm going to invite Deepak ji. Each one of you is requested to join us tomorrow at the New Year Eve at Masonic Club. This is, and you are invited with your families, friends. Do come and make that program also a grand success. This is a cultural program. Do join. Bring your friends and families together. Thank you, friends, and join us for the tea.
At the last, I would also like to thank Sanjay Verma ji, who from Official Recruiters, who is with us since morning. He had made the presentation for Mr. Gautam, but which is didn't come due to some reason. Which had been by Mr. Neja. Kindly give him a big round of applause for Mr. Sanjay Verma. I'll request Vineet Chaudhary to kindly present a memento to Shri Verma ji. Yeah. As a token of love and regard. Sir, आप ना
He has done a lot of work. Thank you very much, sir. Thank you very much, sir. This is my pleasure. Thank you. We'll take more opportunities because this is a very, very altogether different topic. We have a lot of expectations in this topic. We want